Good evening. My name is Bob Liff, and this is the CUNY Forum, a monthly town meeting that brings prominent New Yorkers together with faculty and students of the Edward T. Rogowsky Internship Program in Government and Public Affairs. New York last year drastically reformed rules concerning bail and trial procedures in response to what activists and lawmakers saw as a racially and ethnically stratified criminal justice system where equal justice under the law was more slogan than reality. Declining crime rates, coupled with a heightened attention to issues of racial justice, have pushed a pendulum that once demanded harsher and mandatory sentences to New York's recent reforms that have severely limited the number of charges that are subject to any bail at all. It's important to remember that bail is supposed to serve primarily as a guarantor that a defendant will return for court proceedings and trial. And a trial is about the rights of the accused, no matter how much empathy we might have for the victim. And when the state can take away your freedom, those protections for a defendant are at the core of rights outlined in the U.S. Constitution and centuries of law that have ping-ponged between a more stringent and more merciful system of justice. Proponents of the reforms argue that abuses, including the imposition of even low bail conditions that poor defendants cannot meet while those with greater means can, have deepened racial and economic biases baked into the system. Judges are like the rest of us, including police officers, prosecutors, and the activists trying to rein them in, and having biases that can color how that justice is processed. But it can be argued that just as removing judicial discretion led to sentences far too heavy for the crimes charged, forbidding the consideration of whether a defendant poses a continuing danger to society at large, can lead to the release of repeat offenders, or at least those accused of the most recent of their alleged repeat offenses. Why not let judges judge? Now the state Senate is taking another look with an eye to reforming the reforms, responding in part to complaints from law enforcement that they are too lax, and media stories about repeat offenders exploiting what critics see as a revolving door criminal justice system. Assembly leaders are saying, slow down, let's give the reforms time to see if they work. We're joined by 4 observers and participants in the criminal justice system to assess the reforms and whether or not they're likely to change. Dr. Robert Gonzalez is a professor of criminal justice at St. John's University and a former assistant commissioner of the New York Police Department. Jacqueline McMickens is a former city corrections commissioner who is now a lawyer in Brooklyn. Scott Levy is the chief policy counsel for the Bronx Defenders, and Michael Peshin recently retired, although he's still on senior status, as a judge in which he served as chief judge in Brooklyn and head of the appellate term. Scott, let me start with you, since Bronx Defenders were part of the group of activists that led to this. What caused these? What's the justification for this kind of a radical swing of the pendulum?
Well, as a public defender in the Bronx, we have represented tens of thousands of people in the criminal justice system. And what we have seen over the years that we've been serving the people of the Bronx is that pretrial detention, right, and this is detention of people who are presumed innocent, people who have not been convicted of anything.
Which is the majority of people on Rikers, for instance.
Yes, the vast majority of people in the states, the cities and the state's jails are in pretrial. They've not been convicted of anything. That even a few days of pretrial detention can wreak havoc on a person's life, on their family, on their community, and sort of on neighborhoods much more generally. And we saw over time just the ravages that pretrial detention can really wreak. And what we know as well is that the burdens and the harm of pretrial detention fell disproportionately and overwhelmingly on people of color, families of color, and communities of color. And what we also know is that in New York City in particular, where there has over time developed a very strong culture of releasing people on their own recognizance, that is, releasing people pending trial without any restrictions, without any conditions, is that you can do that effectively, you can do that safely, and that people, when released on their own recognizance, overwhelmingly come back to court without any problems, and that the mechanism of bail and pretrial detention not only, I think, stood in direct contrast to the presumption of innocence that sort of is supposed to underpin our criminal justice system, but it was just not effective or a necessary component. So we were very happy to see the sort of transformational bail reform that came out of Albany last year, and what we are seeing now overwhelmingly is that it is working.
Let me, Jackie, there's been community concerns. I mean, You know, you are a lawyer in Brooklyn. I mean, are people comfortable with this?
Yes, they are, and it's long overdue. People were making decisions about a community where the people returned without having any community input. I mean, if there's going to be any restraint at all, it should be as a consequence of that inmate's behavior, that defendant's behavior, not because he happens to be needing bail. Bail is not and is standard by which a person should be incarcerated. It costs almost $1,000 a day to keep a man in jail. Most of those prisoners don't make $1,000 a day, but they do make whatever they make. They cannot make it in jail. Many of them lose their jobs as a consequence. But I do think that there are some times when you might need to not release him. But those times...
Is that the issue of dangerousness? New York State cannot consider dangerousness, even though judges do.
No, I think bail is a presumption. You have bail that you would appear in court.
Yes.
And so if you don't appear in court 10 times, I mean, what do we do? I mean, so if he's doing something he's a burglar, for instance, and it's his 7th time, I think you should ask the community whether they want him back. And so and I'm not saying that there should be a program that says 7 times you don't, but I do think that there has to be, just to make the community safe. If in fact the community feels that every time you arrest, I call you and you arrest and he's home, then there's a problem. So it's a community issue about how one accepts and uses this wonderful system, because I think it should have been done years ago. Jails and prisons were overcrowded merely because people could not make bail. And you were talking about bails as something as simply as $500, and the city would not take charge cards years ago. Mm-hmm. And how ironic. We don't have a bed for somebody, and we won't let his mother come and do a charge card for $1,000. Because most people could charge $1,000, but there wasn't a process that allowed them to get a person out on bail by cash bail through charge. So the prisons were overcrowded for the simple reason that now has been corrected. More people in jail because they could not make that bail than there were for a degree of crime. Most of them go home. We had a kind of a slogan. He'll come back, but he'll go home this time.
So, Mike, let me ask you. I mean, you've sat on the bench and dealt with defendants. You know, I believe that the lack of judicial discretion is one of the key issues. Explain to me the issue of dangerousness. Can you assess the danger that a defendant and accused poses in making a bail decision?
You could make a educational, informed decision on that. It's not foolproof, but given all the knowledge that a judge gathers from the record, from statements by defense counsel as well as the prosecutor, you can make a good argument for either not being dangerous or being dangerous. But that is not an item that judges are supposed to consider in New York State. There is an effort to amend.
They can consider that,
cannot.
But they can in other states.
They can in other
Right.
states. So the New York is sort of backwards, somewhat behind the other states when it comes to allowing judges the discretion to consider dangerousness. There is an effort in Albany to do that. But the theory of bail is to increase the chance that the defendant will come back to court. And so the state doesn't have to spend resources sending out a bench warrant, finding the individual, rearrest him, put him back in jail, bring him back before the court, which is very expensive. So the theory is to ensure that the defendant comes back to court. The manner in which all of that was done that has created this debate is what's really responsible for what has occurred. If the manner in which the law was enacted had been somewhat more studied, careful, not rushed, it's very interesting. People in government know that you can place in any legislation things that have absolutely nothing to do with the bill. As I call the bill is the legislation. And so you find, for instance, that this drastic change, albeit mostly for the good, was placed in the budget. So the way the budget is done in Albany, you know, it's the day before the session.
The big ugly.
Big ugly.
Right.
The session is ending tomorrow. So everyone is on deck and you work around the clock from morning until night, into the night, passing legislation, and every 2 seconds or 2 minutes, you get a stack of papers on your desk in Albany. I've lived through it. And you say, what is it? And it's explained in like 2 or 3 words. You've never seen it before, and you're asked to vote on it. And what happened here is that this huge package, great changes, history-making changes, was placed inside the budget. In other words,
There wasn't as much serious consideration of all the
at
implications.
all. And it's ridiculous. And this is where the famous expression fits quite well. There are 2 things you don't want to know how they're made. 1, laws. 2, sausages.
Well, you're an excellent chef, so you take sausage very seriously.
Yes.
Robert, underlying this entire debate
Right.
is the issue of race.
Right.
And the issue of racism bias that is baked into this system.
Right.
And that was in many ways a driving force at a time when crime rates are going down, incarceration rates were already going down.
Right.
So
Well, we know with certain issues like stop and frisk, we know that black and brown people were stopped predominantly a lot more than our white counterparts.
grotesquely out of proportion.
Right, and we know that through the research. We know that the arrests are up now, in the city. We know that crime is up now. But crime has been up even before the bail reform was actually passed.
Although even the mayor, the police commissioner, and to some degree the mayor is a little bit more measured,
Right.
are pointing to the bail reform change
Right.
as the different factor for the rise of crime in January.
Right. Well, again, I think, in my opinion, I think they're cherry picking particular cases that they want to exploit to say that these particular incidences are the reason why crime is increasing. We know that over the last year, crime has been increasing for the last 20, for about 20%. Since the legislation has been passed, it's increased 20% within that time frame also. There are different things that we need to consider. Morale has been low in law enforcement for the last year or two. Ever since Officer Pantaleo with the Eric Garner case was terminated from the police department, morale went down in law enforcement. So the officers almost started depolicing. So that had an impact on the increase in crime. In addition to the bail reform, we have issues now with police officers being paid predominantly lower in New York City than other jurisdictions.
Especially the suburbs.
Especially compared to the suburbs. So that also impacts morale. So unfortunately, there are police officers out there who are taking a more reactive approach to engaging the public right now, as opposed to a proactive approach is what they were doing
As
years
opposed to
ago.
the community policing proactive approach.
Proactive approach. So we think that right now the climate in law enforcement, where again, in New York City, they're taking a more hands-off approach to engaging and the public. And I think that has a complete impact on the increase in crime, not just the bail reform.
Jump in on this. I think the climate, the political climate
Right.
within law enforcement
Right.
and the political climate in the broader community very much drove this debate. And I have spent a lot of years as a reporter, including reporting for tabloids, and the impact of sensational cases, which are sensationalized, whether it's a young man, Khalif Browder, who was stuck for over 2 years in jail because he couldn't make a very low bail and eventually committed suicide when he got out, or the people who have been arrested 15 times, including 3 times since January 1st, and essentially laugh at the system as they walk out the door. Those kinds of, that's also part of the climate that kind of drives a lot of this debate.
I think that's right. I think it is part of the climate, and I think that's actually part of the problem, right? These cases are in no way emblematic of the larger system, because what we know as public defenders and what we see sort of on the front lines in the courts every day is that there are tens of thousands of people across the state of New York going home to their families, going home to their children, keeping their job, keeping their home, keeping their shelter placement, right? Waking up in their own bed, having dinner with their kids. Those are stories there are tens of thousands of those stories. Those are not on the front page of the papers, right? That's not something that papers find compelling. It's not what's driving the narrative, but it is the reality of bail reform now.
And New York City is behind the times.
In what
We are
sense?
very, very behind. I applaud the legislation. The judge is right. It probably got put in the middle of the night. But it was not the first time that has been talked about in Albany. This has been over and over again talked about, and it never got in its place. This time it's there. People are reacting to it because the judge is right. Nobody talked about it. It came as a surprise. It really isn't a surprise for the legislators because it's been talked about for many, many years. And I've been out of corrections for many years, and it was talked about when I was there. Right. There is absolutely no need to keep some people in jail because they cannot make money. They just paid their rent. They don't have money for bail. And the thing that they did, you say, well, they should have done what they did. Well, most of them will go home because they cannot prove that they did what they did. Right. And as for the 20% increase in crime, I agree. Policemen are looking the other way. And why hasn't somebody addressed that? Everybody knows that the morale is low. Right. In the police department, and we know why. Yeah. But fair is fair. If you don't follow the rules, you lose, right. And you lose your job. Right. And that is exactly what should have happened.
But what happened that is a problem, besides the fact that in defense of judges, they did not allow judges much discretion, if any at all, which is ridiculous, given how important the role of a judge is.
Why is it ridiculous? I think it's very important. Why is it ridiculous?
How can you say to a judge that someone who has had 15 prior non-appearances in one case is arrested for an alleged crime and appears before the judge, and the judge must not set bail? Where's the logic of that? It makes absolutely no sense. So what has happened is that while, correct, New York State has been lagging compared to other states. If I give you an example, I mean, it's appalling. You have a case that goes on for a year and a half. It's ready for trial. We're ready to pick a jury. We have a jury, ready to put a witness on. And that for the first time, you as a defense attorney receive papers that record what that witness has previously said to law enforcement.
This is the discovery reform.
Yes. That was outrageous. It's like by ambush, trial by ambush. You're a defense counsel. You've had the case for a year and a half. You know there's a witness out there, but they will not give you any information about what that witness' role in the case is, other than testifying for the people. And then they say, this is what the witness is going to basically say on the stand. You get that
5 minutes before.
5 minutes before.
Just so everybody everybody understands what Mike is talking about are the discovery rules, and discovery is when each side's supposed to, that the prosecutor is supposed to provide the evidence against the defendant. It has been held as a tool by prosecutors not to give it to the defense attorneys until the eve of trial, even if they've had it for a year. Under the new reforms, at least the initial turnover of discovery material must be made within 15 days, and prosecutors are really upset about this and says that this is an incredible burden. It requires them to hire more people. So
it's also a burden for the police because the police have to turn over this evidence also.
So this is what the issue is. This is
there's
discovery.
a counter argument to that, which is disclosing the name of a witness, perhaps, or what the witness will say, may place that witness at risk, in danger, whatever. We can go into
Although
that.
there are provisions,
This is why,
Mike, there are provisions
yes, there are,
to allow judges to keep the name of that witness.
No, for the prosecutor to make an application.
Right, to make an application to protect the identity of that witness.
Sorry.
Yes, but not giving the judges the discretion to make those determinations. And this is what I think has occurred, and this is what happens when you have these ridiculous methods of making laws. You had the pendulum when New York State was really lagging, go from one end and swing all the way to the opposite.
One end meaning mandatory sentencing, no discretion, take away the discretion, and now you're taking away the discretion.
And you go from one end to the other, and it just doesn't make sense. And why? Is because in between, the process in which you make laws is like sausages.
You know, on that point, one of the things we actually, I don't think that this bill was actually passed in the middle of the night without debate. The bill that, the bail law that we have was actually passed almost identically the year before by the Assembly. Prosecutors and police weighed in
Why
on it.
put it in the budget?
I mean, the lawmakers have made that decision, but this is a bill that
Why
had been
make
talked
it-
about for
Actually,
many,
the
many
governor
years.
made that decision.
Yes.
Right.
Message of necessity.
Right.
Why?
Well, I don't think there was a message of necessity.
They had to be.
But in this case, this was a bill that actually had already passed the Assembly, had been widely debated and discussed. This is an issue, as we've
Not
already
in the same
discussed.
format.
No,
Not
it
in
was
the same format.
the law that was passed actually is virtually identical to what we have now, the one in the Assembly.
Well, I beg to differ. I thought there was some discretion there for judges.
No, this is the law that that was passed in the budget was virtually
I may have to
identical.
go back
Yep.
and look at it. But
Absolutely. This
it
is
was
some-
wrong the first time, and it's wrong the second time.
Well, that's a different question.
And what-
I was
it's
just
true.
gonna say, that's a different question. That bill, it didn't come as a surprise to many people who are in the system. That bill has been debated and debated and debated and was finally passed, and it was
It was
not-
finally passed when the Democrats took control of the state Senate.
right.
It was,
But it was- it has been-
until that year, the Republicans had been in control of the
That's
state
right.
Senate.
It was, that bill has been debated in some form or another for years. It's not new, and it's certainly not rushed. And it certainly lags, Judge. I understand, and I said in my opening statement, I think that there has to be some time at some point where you say, no, you can't go home.
The bill that was passed the year before, when the Republicans had control of the Senate, was expected to be somewhat tapered or changed or make it less swing to the other extreme by the Senate. And it comes out that the Senate, as Democrats, decided not to touch it, because if they started touching it, it wouldn't pass. And so there you have, again, two things you don't want to know how they made. It's like
And it's my
laws-
understanding, that the district attorneys and my colleagues in law enforcement weren't conferred with. The allegations now are that this was passed without their input.
It's not true.
So again, I'm
Well,
only,
they had input
I'm only
and
speaking
passed.
to the leaders who are running law enforcement agencies and to the district attorneys who are all saying the same thing. We weren't conferred with. We don't have the resources. This thing happened overnight. What do we do now, right? Because
Well,
everyone collectively has a
about what are we-
responsibility to
let's
protect
talk about,
the public.
Let's talk just briefly about what are we going to do now. What the state senators and the governor are responding to this public pressure. A lot of it coming from upstate, but not all of it coming from upstate. A lot of it's coming from within the city as well. And one of the current proposals is to do away with cash bail totally, and just have judges judge. I guess you would have to make that judgment based on dangerousness, which you can't do now. I don't know what other that you could either make a decision to hold people, let them out with conditions of home confinement or whatever. I mean, I don't know. There's a lot of discussion going on.
That would be unconstitutional for the judges to make a decision on dangerousness. I mean, that's
Preventive
not.
detention.
Well, is it
Constitutional protection. I
That's right.
guess.
They
right? But
can't do that.
but every other state
But-
judges are allowed to make a judgment in considering
Yes, they
bail
are.
as to whether a defendant poses a threat to the community if they are let out.
And one of the things
And we
that-
cannot make that judgment.
One of the things I think to put in context is that in New York and in New York City in particular, right, judges have not been allowed to consider this ever, right? New York City has one of the lowest crime rates of any big city
It's
in
the
the United
lowest.
States.
The
The lowest.
lowest.
The
The
lowest.
lowest.
Crime has plummeted.
Right. And so
Incarceration is plummeted.
What I think we've actually learned is that the connection between pretrial detention and bail and public safety is actually not what people generally think it is. What we also know from statistics and looking at the data across the country is that when people are released pretrial, overwhelmingly they are not rearrested for violent felony offenses. Something like less than 2% of people who are released pretrial are arrested for violent felony offenses. Even when you look at risk assessment instruments, algorithms that are used in other states like New Jersey, right? The algorithm that they use to try to predict dangerousness labels a small segment of people who are released pretrial as dangerous. That's a small segment of all of the people who are released. And even among those people who are deemed high risk, only 8.6% of those people are arrested for violent felonies. So on the people who we think are the most high risk, we still have a 92% chance. 92% of them will not be rearrested. And so I think what we have this instinct that we can somehow predict the future and human behavior. And what we actually know when we look at it is we're actually very bad at it.
But it's not actually predicting human behavior. It's making judgments. it's an imperfect process, and people make mistakes when they make judgments. But
those judgments are
but
about
it's,
future behavior.
You know, I mean,
Yes.
Police Commissioner Shea made the point in an op-ed that 87% of people who are
A
arrested
discharge within 24 hours.
discharged within 24 hours with no bail.
That's right.
So there is there is somewhat of a limited universe.
9 out of 10. 9
Yeah.
out of 10 people.
But it's, again, I keep coming back to the question because I was very struck with the 1996 federal crime bill, which was at a time of heightened crime, and there was, a loud hue and cry, and you wound up with very severe reforms to criminal justice that mandated very harsh sentences, which led to grotesque injustices because judges did not have the discretion to say that's ridiculous. And the question is, in terms of community safety, does this lack of discretion, even in these limited 1 out of 10 cases, raise the same
Yeah,
kind
we don't need discretion. We have an algorithm now. We
Well-
have AI. let them make a determination.
think
You don't
that-
need a judge to make a determination.
I actually just think that
Just check the
idea that
algorithm.
algorithms or judges can actually predict future dangerousness is deeply problematic, right? Because I think we know that neither are really able to do it, and that both, right? That the invitation to have judges determine who is dangerous and who is not is really an invitation for implicit bias, right? We know that the use of algorithms and the use of dangerousness only exacerbate and codify existing racial disparities in the system. And so I think one of the things we also know about this, what I think is hiding under this discussion about dangerousness and the bail reform more generally, is that what we often think of as criminal justice problems, right? Things that we would have generally tried to solve with the criminal justice system are actually problems that have solutions well outside of the criminal justice system, right? Our jails have become the largest providers of mental health services in the country, right? That should not be, right? And when we look at the cases that often end up in the press, what we find is folks do sometimes have problem coming to court, but the solution is not putting them in jail. The solution is making sure that you call them to let them know that their court date is coming up. We actually know that the single most effective intervention for getting people to court is a phone call, right? We don't need to sort of reflexively default to punishment and incarceration in order to solve these problems. And in fact, what we know over and over again is that defaulting to incarceration, to bail and preventative detention, actually only makes the problem worse. Because as we discussed, people don't disappear when they go into jail.
That's right.
They come back out. And we know that even a 3-day stay in jail makes a person far more likely to be rearrested in the future. So we are, cutting off our nose to spite our face.
Well, just for instance, in the 90s, crime between now and has reduced. New York is the safest city in the country, a large city. But we know that in 1990, there were 22,000 people in jail. Today, in Rikers, and there are 7,000. We don't have a crime spree. We have not had a crime spree. The city has not been unsafe. The city has been as safe as it has been in a very long time. And if it is becoming, and I think one of the things that we have to recognize is that not only that phone call is necessary, but what if in fact he is so mentally ill that he forgets? He forgets to come to court. Take that into consideration. He just didn't show up that day. He's mentally ill. He's got a mental problem. And it's Thursday, but I really think it's Friday. There are no services.
You can
for that.
always offer tickets to a sporting event.
Well, we could. Well, I don't suggest.
I don't know
we
if
do that.
anybody can.
Yeah,
But I do suggest that if in fact you find as a judge, and the man is standing there looking dazed and disoriented, and he's not drunk because he's now been in incarceration for 48 hours. You don't get before a judge in 48 hours. Try that in Brooklyn anyway. It takes you 2 days to get before a judge. And so you're
Not
certainly
anymore.
not. Well,
it's
it takes
less than 20.
No, it's 24 hours at least, Judge.
Yes, well,
And maybe when you were there, you've been gone a while and you haven't been policing them. And so,
I was in criminal court in
but-
arraignment
but-
for a while.
but you judges meet and you talk about the system. However, what happens if you have somebody there who's totally disoriented and he's been in the system 24? Wouldn't it be nice if there was somebody who could say to him, "Sir, are you on medication? Have you not had your medication?" And then we leave with a different paradigm for this man. And so what's wrong with that? If you have a criminal justice system that has a person who's a part of our community who has a problem, why not assist him?
That is supposed to be a part of the pre-arraignment interview done by I don't know what it's called
intake
now.
staff, right?
Staff. But there's an aspect, the critique about, well, you put someone in jail to increase, of course, guarantee that he will reappear. If there are going to be repercussions to the person's not legal problems, that's taken care of by the defense counsel, but the social problems. And what the system lacks is a support mechanism that if bail is set for someone, he has counsel to take care of his legal issues.
That's right.
What about his social issues?
Exactly.
There is nothing for that. And so if you have a job, if you have children, if you have housing, there should be an entity, a safety net that can help, not perhaps solve 100% of those problems, but some of those problems can be resolved if there's a mechanism in place, and we don't have one.
Well, actually, I think we have one, and we are starting to make it more robust.
Defense?
No, and well, I mean, my office.
Your office.
Well,
In your office.
in my office, we have robust social work supports, and we do that work, and we think that is by far the most effective thing for getting people to court, but also making sure that people have successful outcomes in their cases. But what the new bail reform actually does is, in my view, it actually asks judges to exercise discretion in a way that they've just never done before, right? It requires the creation of pretrial services. In New York City, we have actually very robust pretrial services. It was called supervised release. It's now sort of expanded. And in the Bronx, we're very lucky to have Bronx Community Solutions, which is the provider of pretrial services in the Bronx. And they make a wide number of services available to folks on a voluntary basis. They provide those phone calls, they provide those check-ins for folks who need more attention.
Support.
They actually visit people in the community to make sure that they're coming back to court and that they have the supports that they needed. I think before we had this bail reform, while judges technically had discretion to set types of conditions, they really only used one tool. The only tool that judges used was bail and incarceration, right? That was the only tool that folks used. And that wasn't really an exercise of discretion.
No, we use tools. That is the ultimate result. Now, maybe bail, but bail is just one aspect that judges consider.
You also have this situation because obviously the one party in crime that we've not discussed is the victim, and and legal proceedings are about the defendant because the state can take away the defendant's freedom. That's what it's about. No matter how much empathy, as I said in my opening, we have for the victim, but lawmakers, society at large, those outside the legal justice system, are concerned about threats to safety. The fact that crime has been edging up.
Right.
I mean, it's still at levels incredibly lower than it was. And you see the political world reacting. We had a whole series of anti-Semitic attacks early this year, and there was discussion, well, maybe hate crimes should be added to those list of offenses that would be bail eligible. So,
Child pornography.
So there are things in which you politically respond. Are you going to use bail eligibility now as the tool to answer a political problem?
But if you,
and I'm not downplaying
the
seriousness of the anti-Semitic attacks at all.
Oh, absolutely not. And we found out that the man who did one of them was mentally ill. And so what?
And then the federal government, in a grotesque overplay, decided that because the state couldn't give that person bail, they were going to come in and arrest this person. Just a grotesque overreach.
He's in a mental institution. And I don't know anything about this, and I don't know whether he'd ever been incarcerated before, but I wanted to say something about the victim. The crimes that people commit, the victim has a right to ask for some protection. But where do we have the study that says that because he got out on bail, he committed another crime, and that victim? I mean, we don't have that discussion. And that discussion, and people are hysterical about that. Well, I asked the victim, where is
well,
the
there
victim in
are
this?
people, I mean, there are more cases than we care to talk about it in terms of people violating orders of protection. So there
Well,
are
that's-
clearly cases in which you have.
And those orders of protections are just orders of protections. They do not protect women. And we know that. The orders of protection, there's too many cases in the country, not just New York, where women have had orders of protection and it's a piece of paper. And the husbands continue to batter them and they continue to do whatever. There have been deaths, we know. We're not sitting here, I don't want to talk about what happened recently, but you can have an order of protection and it's not going to protect you if in fact the police do not police and assist you. Those orders of protection are merely pieces of paper.
And it's the case that a repeat offender can, in fact, somebody who violates that order, that is bail eligible.
Absolutely.
That
It's bail
Right.
ineligible.
No, but violating the order is
Protection.
is a,
Somebody-
that,
Makes him
that
bail
the level.
ineligible.
No, that becomes bail eligible.
That
I
is
believe
bail
if you
eligible.
violate the
You can
order.
set bail.
You
Yeah,
can set
you
If you
bail.
can
violate
set
an
bail
order of
in that case.
protection,
That's right.
you
Yeah.
can set bail.
That's right.
Based on that alone.
Yes,
And,
yes.
and that's my point. So the system is not without some restraints on violent behavior. So you can't just say that, and I would hope that it is not, judges are respectable, wonderful people. However, if I am looking at a person who has been arrested 7 times and I'm a judge, and I really think that you didn't come back the last 7 times, I don't think that there's anything wrong with saying, no, you have to stay home this time. And those are the kinds of things that I think. But other than the kinds of things that judges should be able to look at and say, you have disrespected the system, then we ought to continue to do what this bill suggests.
And in that case, would you think that a judge could impose bail, or a judge could simply incarcerate that person without bail, hold them?
He could decide, he could do the bail significant enough if he can make the bail. You see, we can't deny bail to people if they can make it.
But you also have the case, the obvious disparities between somebody, a $500 bail means a lot less to me than it might mean to somebody.
But the judges are aware of that. We consider that. We consider the means that the defendant has. And it's just, again, bail is one tool. You can impose all kinds of conditions. You can require the defendant to come back to your own courtroom once a month, if necessary. There are all kinds of tools. You just have to give the judges discretion. You have to trust.
The question of you have to trust judges because, is the loss of discretion a recipe for injustice?
I mean, it could be. I mean, like I said, we're throwing out a lot of different ideas. To your point, when you talk about emotionally disturbed persons, I know law enforcement officers in the street, through my experience, 23 years in law enforcement, we're actually discouraged from treating someone as an emotionally disturbed person versus arresting them. Because when you treat them as an emotionally disturbed person, it's a huge drain on the officer. Another officer has to go to hospital. Another officer has to sit with them in a confined space, for days even, right? But if you place them under arrest, you're with them for 3 hours. You turn them over to the criminal justice system. You wipe your hands of it, and you're done. Right? So officers are often, especially supervisors, discourage cops from treating people as emotionally disturbed versus just making a simple arrest because the drain on resources in law enforcement.
I know, but I hope you're not equating discretion that cops use with the discretion that judges should have.
No. I'm just to her point.
He's doing it practical because what happens is they rush them to send them to Rikers.
They have a discretion.
And
Police
they-
officers have huge discretion
And
at
they
the time
kn-
of arrest.
And Judge, they know that they're mentally ill. They just don't want to be bothered with them. So they send them to Rikers where they're mentally ill and they sit. And when they get to you, get to before the judge, he's already in jail, so why would you let him out? I mean, it really is, unless he can get bail, then he stays in jail. And really, his parents don't probably want him either, because what do they do with him?
They want him out of the house.
They want him out of the house. So there's no incentive to give, and there's no place to put him other than Rikers.
Yeah.
And so
Yeah.
so if you let him out on bail and he's on medication, he can probably continue his medication. But if you have him in Rikers and it takes days for him to get his medication, what have we done here? We have treated him unfairly.
They say half the population in Rikers is mostly
I don't know now. I mean, I only they say there are 7,000 people there, and I don't know. I don't know if there's a study, but I do know in any jail population in my 20 years,
Right.
a good third of them were mentally ill and should not have been in jail.
In about 25 years of dealing strictly with criminal matters, I've had parents who have come to the courtroom at arraignment asking through the attorney to impose bail because they did not want the son or the daughter to come back home because they were creating problems because of drug use. We had prostitutes who will tell counsel, please ask the judge, I'd like to be in jail a couple of days just to rest. I've had murder cases which I've released the defendant in his own recognizance. I've had cases where there's mandatory jail time. I took a plea and I would have him come back to me like probation once a month to my courtroom to see what he was doing. Was he working? The discretionary aspect of a judge's role is very important.
Although I think a lot of the issues that we were just discussing, right, that the answer to so many of these questions isn't judicial discretion. It's not courts or prosecutors or the police, right? I think that's actually where we are. We're at a transformative moment where when we see someone who is going through substance use issues, right, or going through mental health. I mean, what I can say, just sort of in my experience, is really what unites most people who are sitting on Rikers Island is the experience of trauma, right? The experience of trauma that drives people into the criminal justice system, the experience of trauma that they receive while they are incarcerated,
right.
while they're there. And I think,
And so-
right,
and so-
but I think what this
How do you
moment is,
solve the trauma? Trauma.
well, I think what you do is you say the criminal legal system is not the place to do it, right? We need to invest in housing resources, mental health resources, so that the only resource that is available to people is not jails, right? We've for too long invested in incarceration and punishment instead of support and services that people need, right? So that it has become the place of last resort. But I think what we are seeing now, and what this bail reform really does, is forces us to ask some really tough questions.
Mm-hmm.
Should we be relying on the criminal legal system to do all of these things that is not particularly well equipped to do?
Sir, tell us your name and your campus, please.
Hi, how are you doing? My name is Joseph Cho, and I'm currently a junior at CUNY Queens College. So my question would actually be regarding on the issue of cash bail. Criminal justice reform has been an issue that recent Democratic presidential candidates have touched upon widely, especially on cash bail. Senator Bernie Sanders himself has actually come out in favor of eliminating cash bail on the federal level. And if elected, he stated that he would encourage states to do the same as well. So my question would be, if cash bail was to be eliminated in the state level, would that solve a majority of issues that we face in our criminal justice system today?
Very good. And that's sort of the proposal that's floating around in the state Senate now, is to eliminate cash bail, and then the burden becomes on the charging prosecutor and on the judge to make that interpretation. Is that?
No, you're taking more discretion from the judge.
I'm not sure I quite understand, but the proposal is in fact to do away with cash bail totally in the state system.
To be fair, I'm not sure we know exactly what the proposal is.
No, I was
On the larger question, I think one
You
of
can
the
get a bond or credit card.
I think one of the things that has been lost in the discussion about bail and pretrial detention is that the harm that I think we really ought to be concerned about, the harm that we should be addressing, and the thing that we are trying to fix, right, is the sort of expansive use of pretrial detention and the destruction that it has wrought on communities of color across this country, right? And so when we're evaluating proposals to change the pretrial detention system, the first question we should ask is it decarceratory, right? Are we creating a system that moves more people out of a system that has, destroyed entire communities, right? I think I think it's very hard to evaluate any proposal in a vacuum, right? I think we have to look at it in context, and we have to say, will this result in further decarceration? Will this result in the further dismantling of a system of jails and prisons across this country, where we know we have the highest rate of incarceration in the world, right? And so when we're thinking about reforming the system, I think the first question we should ask is, where are we now, And what is going to get us to that place where we have more people sort of with their families, with their children, keeping those jobs, doing all the things that they need to do? And are we creating a system that really respects and guarantees the presumption of innocence, right? Because that is something that really doesn't.
I want to go to another question, but how much of that is linked to the racism that is, not only baked into the system, but baked into the society at large, far beyond, because to a large degree, I mean, you saw it even in the distinction between penalties for crack cocaine and powder cocaine. One being, much more of a upper middle class white phenomenon, and one being much more likely to be in people of color. And the crack cocaine penalties were grotesquely more. How much of this is driven by implicit bias, explicit bias, however you want to look at it?
Mm-hmm. Well, again, you made a good point. I mean, one of the issues in we have to remember how this whole thing came about, right? There were issues about how black and brown people were being incarcerated versus their white counterparts, how they were able to raise money for bail.
Incomparable charges.
Right, exactly. So we got to remember how we got here. And I think everyone agrees, on the panel, that there were some issues. Perhaps we can also agree that, maybe the legislation just needs to be tweaked, right? It was necessary, but maybe they didn't converse with the stakeholders involved in this process. It appears, and we're hearing that maybe not, that it was rushed through, to get voted on, where, now we're hearing that maybe that wasn't the case, right? That this debate's been going on for years. So me, in my professional opinion, I just think that there are some components of it need to be tweaked with discovery. As far as the racial issues are concerned, discriminatory issues, I think that also needed to be tweaked also, because it seemed as if the jails were more populated with brown and black individuals versus their white counterparts. So we as a community, we as a society needed to look at this and come up with a comprehensive plan.
Yes, sir. Tell us your name and your campus, please.
My name is Kevin Trujillo, and I'm currently a senior at CUNY Lehman. My question is, how can modern-day technology help a judge's discretion when sentencing people?
That's an interesting question about modern technology. I mean, you have...
We're going to create some algorithms.
Yeah.
I mean, they're working.
Well, no, right, but I mean...
Start working on it.
I mean, you have home confinement but are there ways you can monitor somebody at home?
Ankle bracelets. They have
ankle bracelets and stuff.
Technology.
I mean, but even beyond that...
Bail is just one tool. They're all, as I mentioned earlier, there are many, many ways in which judge can, given the discretion, can fashion a release of someone without feeling that you're endangering
the community.
May I ask you a question? I think that how can technology help?
Yes,
Modern day technology. Why the use of modern day technology just to study this period where before it's tweaked again? What does the community suffer as a consequence of this system, this part of this time that's going on? I would suggest that nobody has, I don't know, but I suggest that nobody has taken a very comprehensive look from the day it started and every day what's happening with that. And those tools are available to us, but I would suspect that in the hysteria of, we discovered that you let everybody out on bail, and that's not, everybody's not getting out on bail. But there is the discussion about how we discover and study this is not part of that equation. And as the judge said, it's a good project for someone who's in this system, who's interested in this system, because it is very informative. If people are aware of what's happening, people are not mean naturally. American blacks make up 13% of the American population. We are 40% of the jail population. You do the math. There is no way to look at this system and assume that it is not racist. It is simply no way for 38% of a 13% population to make up all of the prisons and jails in this country. Let's just be fair. We're talking about an economic system that keeps people who are already disenfranchised in the system. And so how do we talk about that? Do we then lump all blacks in the same, they are getting out on bail? Husband, wives, sons, kids who have jobs get arrested for running red lights. They have a job. They have to, and they spend 24 hours in jail. They may lose their job. There is no reason to tweak this system to the point that it changes its very nature. It is a good thing that New York has followed suit of other states and done what they've done. They've been behind the times, and I applaud the governor and I applaud the mayor. We just need to understand that this is a racist system. And let's stop talking about it as if it is a system. And so let's talk about it for what it is. It is a way to disenfranchise people who are already disenfranchised.
Yeah, but what do we say to those victims who someone should have been incarcerated, they get released on, on no bail,
Okay.
and then they go on, they reoffend. So what do we say to that victim who gets victimized when the person should have been incarcerated?
But we don't know they should have been incarcerated. Maybe they should have been in a mental institution.
Right.
Maybe they should have been in school. I asked a question, why was a 13-year-old running around in Central Park? Why? What 13-year-old is allowed? What 13 in this room would be allowed to be out at 11 o'clock at night? So there was no place for that kid to be. He's 13 running around with a 14-year-old at 11 o'clock. Who's taking care of these kids?
You're talking about the case in
Yes, I'm
Morningside
talking about,
Park.
and it breaks my heart. But
That's so dangerous.
but you see, one of those kids had been in jail, so now we don't. Ooh, putting him in jail wouldn't have stopped. Keeping him wouldn't have. The problem is that we have to have systems and services in place to talk about the things that are causing kids to do these things. We're talking about a very young population. And so why are they there? And so why don't we ask that question? If in fact he's been arrested once, why are you back? What happened in between? And so when are we going to begin to ask the questions, why is there crime for this population?
Quickly.
One of the things that I heard in the question that we just got was, how can technology help judicial discretion? And what we know is that bail reform across the country is overwhelming. It's starting to rely more and more on algorithms and sort of computer modeling, things like that. And I think sort of a perfect tie into what you were just talking about. What we know is when you create algorithms, right? When you try to use technology and big data to try to help inform and influence judicial discretion, in order to build those tools, you have to draw from data from the existing world. And
Exactly.
that data that we have is infected by systemic and structural racism, right? We know that black and brown people are more likely to be arrested, more likely to be prosecuted, more likely to be charged with higher crimes, more likely to be convicted, right? At every decision point along the way in the criminal legal system, we know that black and brown folks are getting disproportionately and overwhelmingly being harmed. If you take all of that data from the existing system and then create a tool, right, a data tool to help predict things, you are necessarily going to recreate and exacerbate those problems, right? So to the question that we heard about how technology should be used to help influence judicial discretion, I think we need to be very, very skeptical of sort of laundering decades of history, not just decades, hundreds of years of systemic and structural racism through facially neutral algorithms.
Yes, sir. We've got about 3 minutes left.
My name is Noor Khan from Baruch College. You stated earlier that a piece of paper will not be sufficient enough protection for women. I was just wondering what other solutions there would be to mend such an issue like that.
Well, actually, I have to say that the police department is now very serious about orders of protection. In the past,
They do home visits, they have special units.
in
they
the
go out
past,
and
it wasn't
monitor.
so.
No, you're right.
It
Yeah.
was a slow cultural change
Yep.
within the police department
Right.
to take orders of protection, violations of order of protection, seriously,
Right.
to a point where the pendulum on that issue has swung in the opposite.
In a good direction,
Yeah.
right?
Good direction.
Well, too far perhaps, because some of the complaints are like, it wasn't me.
Yeah.
No, but there's a report, there's a phone call, you're coming in. It wasn't me. It doesn't matter.
We got about 2 minutes left. When you look at the political pressures that always surround criminal justice issues, it's got all the racist history baked into it. It's got legitimate concerns about crime. People suffer. Victims of crime don't experience that in the aggregate. They experience it one by one. We're talking about, judges have to deal with the case in front of them, as opposed to some kind of broader societal issues. You have a case, each case is discrete. Where is this debate going to go? How do you see this? How do you see these attempts to reform the reform going?
What I will say is I hope it forces us to really take a step back and think about what it is we have been doing up until this point, right? I think what we know now is that we have been getting it very, very wrong, right? We have been harming vast numbers of people, overwhelmingly black and brown folks. And that, again, the solutions to these problems does not lie in the criminal legal system, right? It lies elsewhere. And hopefully we can start redirecting our resources to those systems of support and the systems of services that will keep people out in the first place and that will respect the presumption of innocence.
I'm sorry, go ahead.
It costs almost $1,000 a day to keep a person in Rikers. Most of those kids never make $1,000 a week. So what are we doing? And we've been doing this for so long. I am so happy that this happened. I don't know what to do. But I do want to get back to those of us who advocate or should have data. There's no place to get the data to say, no, there weren't that many crimes. No. We don't have the data, and there's no place to get it. Vera Institute is not doing this. I mean, where do you get the data to say it's a very good thing? So the question that he answered, I'm not saying you use data to decide who's a criminal or not, but I do think data is good for the community to know. I think reporting is good. I think that good, accurate statistics are very good. I think the system has not done that in a way that allows me to be an advocate.
I've got 7 seconds left, and I always make deadline. I want to thank everybody. This is a very spirited discussion. This issue is going to go on. We'll see you next time on CUNY Forum. Thank you.